Can I start by apologising for the late start of this hearing? I'm told this is a result of GeoAmey being late in bringing one of the defendants to court from prison, despite the very best efforts of the GeoAmey staff based here at Preston. I know that these delays cause additional stress and anxiety, especially to victims and their families, and I'm sorry it's happened in this case. In this case, the defendant Catherine Hudson, who is aged 54, is to be sentenced upon her pleas of guilty to the following theft matters, namely counts 9, 11, 12, 15, 16, 18, 19 and 20, and for perverting the course of justice on count 17. She'll receive 10% for her credit for her plea to count 12 and 15% credit for her other pleas. She was convicted by the jury of counts 1, 4, 5 and 6, all alleging ill treatment or conspiracy to ill treatments in her care, and of count 23, alleging the theft of mebeverin. The defendant, Charlotte Wilmot, who's aged 48, is to be sentenced upon her pleas of guilty to the following theft matters, namely counts 15, 18, 19 and 20, and following conviction by the jury on counts 3 and 4, alleging the encouragement of ill treatment of one patient under her care and the conspiracy to ill-treat another. She'll receive 25% credit in relation to the offences to which she pleaded guilty. Finally, Marek Grabanowski, who's aged 46, is to be sentenced upon his pleas of guilty to the following theft matters, namely counts 11 and 16, and for perverting the course of justice on count 17. He will receive 20% credit for his pleas. The trial in this matter took many weeks. It is a highly unusual case. I feel it is necessary to set out the facts in some detail. All of the defendants worked at the material time at the Blackpool Victoria Hospital. Catherine Hudson was a Band 5 registered staff nurse working on the stroke unit, and she'd worked in this capacity apart from a short break since 2010. Charlotte Wilmot had been a Band 4 assistant practitioner since 2012. From 2014, she worked in that capacity on the stroke unit at the hospital. In that role, she did not have the authority to handle medications. Marek Grabanowski was a nurse in the A&E department at the hospital. He is the partner of Catherine Hudson. In short, this case concerns thefts by these defendants of drugs from Blackpool Victoria Hospital, and in the case of Catherine Hudson and Charlotte Wilmot, the ill treatment of vulnerable patients in their care by the inappropriate administration of sedative medication, or the agreement or encouragement to administer such medication. Catherine Hudson and Marek Grabanowski then sought to destroy evidence to hamper the police investigation. During the trial, there was a good deal of evidence before me to the effect that the stroke unit was, in certain respects, poorly managed. Most strikingly, there was little proper control on certain medications. This meant that staff were free to steal or otherwise abuse medications, which should have been strictly controlled. Those included antibiotic and prescription-only medications, and most importantly in this case, Zopiclone. Zopiclone is a sedative. It is available on prescription only and is a Class C controlled drug. It's licensed for short-term use in the treatment of insomnia in adults. It is a dangerous drug in that in overdose it can cause coma. It can cause psychiatric and other adverse behavioural effects. Its use must be carefully controlled and monitored, especially in the treatment of stroke patients. Zopiclone and other drugs were kept in the treatment room on the unit. However, it was also kept in cupboards on the wall in the patient bays of the wards. The cupboards should all have been locked. However, they would often be left open. Sometimes Zopiclone and other drugs were kept in the patient's bedside lockers, which were again often not locked. Drugs would go missing. Sometimes they were found, but sometimes not. Once concerns were raised about Catherine Hudson, and following an investigation in November 2018, it was found that Zopiclone and other drugs were not subject to any specific checks on their ordering, storage or administration. After the matter was raised and Catherine Hudson's use of Zopiclone was called into question, the use of Zopiclone dropped very markedly on the stroke unit, as demonstrated by graphs placed before the jury during the trial. There was evidence that staff walked around the ward with medications including Zopiclone in the pockets of their tunics. It's against that background that there was wholesale theft of drugs by members of staff, and in the case of Catherine Hudson and Charlotte Wilmot, an ability to give or plan to give Zopiclone to patients for their own purposes, without, as they thought, the risk of being held accountable. I'll deal firstly with the thefts. All of the thefts in this case are serious because they are thefts in breach of trust by professional people. Though 2 of the drugs stolen were available in different forms over the counter, all drugs as stolen in this case were prescription-only drugs. Zopiclone is, as I've already mentioned, in addition, a controlled drug. Drugs are controlled or regulated by prescription for a reason. The prescription drugs stolen by the defendants represented a risk to anyone who took them without proper medical oversight. We are all aware of the dangers to public health of the unregulated use of antibiotics. However, the theft of Zopiclone is, in my judgment, the most serious of these offences, given the risks associated with it and its status as a Class C controlled drug. Turning to the individual defendants, of Catherine Hudson's theft matters, 3 relate to Zopiclone. The earliest theft of any drug was committed in 2014 and the latest in 2018. She told the jury she'd taken some for her partner, her partner's father, and some for a colleague. The one theft matter she did not admit, and in respect of which the jury convicted her, was the theft of mebeverine. This arose from a text conversation with her partner, who was asking her to steal the drug for him. At first, apparently, she couldn't find any. However, she later sent him a text message saying, open quotes, "I've found some mebeverine of a patient's. She won't be using them. She's end-of-life care. That sounds so bad," close quotes. Of the 4 theft offences to which Charlotte Wilmot pleaded guilty, none relate to Zopiclone. She said in her evidence that she had stolen drugs for family members or on one occasion for her horse, presumably to avoid vet's bills. Both theft offences committed by Marek Grabanowski were conspiracies to steal with Catherine Hudson. One relates to Zopiclone, one is in 2015 and one in 2018. I turn now to the ill-treatment counts, and I will deal with each of the ill-treated patients in turn. Aileen Scott was admitted to the unit on the 22nd of October 2018 and remained there until her transfer to Glasgow on the 7th of November 2018. She was, in comparison to many of the patients on the stroke unit, alert and active, though there was a DNAR, do not attempt resuscitation, on her notes. On the 2nd of November, Catherine Hudson was mentoring a third-year student who I will refer to as Nurse A, as the Crown have asked me not to name her in these remarks. During the course of their shift, Catherine Hudson asked Nurse A how the patient had been, to which Nurse A said that she had been unsettled. Catherine Hudson suggested that she should give her some Zopiclone. Nurse A protested as it wasn't prescribed to Aileen Scott. Miss Hudson said that Miss Scott had a DNAR on her notes, and if any harm was caused to her, she would not be, as she put it, opened up, meaning that there would be no autopsy. Nurse A told Catherine Hudson that she shouldn't say such a thing. Notwithstanding this protest, Catherine Hudson took a strip of Zopiclone from her pocket and administered a tablet to Aileen Scott. Nurse A was shocked at what she'd seen and told a friend, who then helped her with the process of coming to terms with her duty to blow the whistle. It's clear from the evidence that we have seen that Nurse A was, as I suspect many whistleblowers are, very frightened about the consequences of talking about what she had seen. She was a trainee, whereas Catherine Hudson was a loud and outgoing senior member of staff. Nurse A, however, took that courageous step of reporting what she had seen. She is to be commended for those actions. It's only as a result of her courage and clear sense of public duty that what was happening on the ward was exposed and stopped. In covert recordings, we heard what Catherine Hudson was saying to others in the days after she'd been arrested and interviewed. Catherine Hudson commented to her son that there was, as she put it, a little inside rule on the stroke unit. She went on, "You all just stick together. It's just taken to the ground." Put to her on behalf of Catherine Hudson that she was a liar when she wasn't. Attempts were made to discredit her when all Nurse A was doing was telling the truth and trying to protect the public. I stress that whilst there is loss of credit, the nature of Catherine Hudson's defence will not add to the sentence, and I make no criticism of her counsel. He was acting on the instructions of his client, but I repeat, Nurse A is to be commended. Count 1 alleges a single administration of the drug. Catherine Hudson will only be sentenced for one single administration to Aileen Scott. The impact of this offence has been set out in the moving victim personal statement of Aileen Scott's son, which was read out to the court by him yesterday. It's true to say that the discovery of what had happened to Aileen Scott has caused terrible grief and upset within the whole wider family. I thank him for his statement. I turn now to patient B. Charlotte Wilmot alone is to be sentenced for encouraging Catherine Hudson to ill-treat patient B by the administration of sedative. Catherine Hudson was acquitted of actually doing so. Patient B was admitted to the stroke ward on the 31st of January 2017 and remained there until early April 2017. He was very poorly and solely as a result of his illness sometimes presented with challenging behaviour. The evidence in relation to patient B comes from messages between Charlotte Wilmot and Catherine Hudson. These messages almost all included emojis indicating expressions of extreme mirth at what they were saying to each other. I will not read these out, though in my remarks I will expand upon certain abbreviations. At 9 p.m. on the 2nd of February 2017, Catherine Hudson administered Zopiclone to patient B. There is no suggestion other than that this was appropriate. He was prescribed Zopiclone and this dose was recorded in his notes. However, at 6:47 the following morning, Catherine Hudson sent a message to Charlotte Wilmot saying that she was going to, as she put it, kill bed 5. Bed 5 was patient B's bed. Charlotte Wilmot responded, "Piss myself laughing, well tonight, sedate him to high heaven, laugh out loud." And Catherine Hudson responded by saying, "Already in my head to give him double." To which Charlotte Wilmot responded, "Ha ha, thought it might be." This was, as the jury found on clear evidence, an encouragement on the part of Charlotte Wilmot improperly to sedate. There was further discussion about patient B having been sedated on the shift from the 4th into the 5th of February, but of course in accordance with the jury's verdict, this was done appropriately. However, it does indicate Charlotte Wilmot's attitude to that patient, and also to the question of sedation. Catherine Hudson sent Charlotte Wilmot a message which read, "If bed 5, which was patient B, started, he'll be getting lol, lol, he was gearing up to start. To which Charlotte Wilmot replied, piss myself laughing, was he? Catherine Hudson told Charlotte Wilmot that patient B was, as she put it, out like a light, to which Charlotte Wilmot responded by saying, piss myself laughing, praise the Lord, accompanied by pictures of pills and syringes. As distasteful as this exchange was, and indeed Miss Wilmot admitted it was in evidence, I stress there was nothing criminal which took place during this shift. However, it does indicate how Charlotte Wilmot viewed patient B. To her, he was a nuisance. He was a troublemaker whose sedation was a cause of humour, satisfaction and ultimately celebration. I turn to Janet Westhead. Both Catherine Hudson and Charlotte Wilmot are to be sentenced for conspiring to ill-treat her. Janet Westhead had been living semi-independently until she was admitted to the unit on the 16th of February 2017. She was to remain there until the 16th of May. Sadly, she died the following December. She was very poorly and very vulnerable to being ill-treated. Her daughter, who gave evidence before the jury, was distressed at the rapid decline in her mother's condition once she was on the unit, and she was clearly very forthright in dealing with the staff about, as she perceived it, the lack of care for her mother. It is clear that these defendants came to regard Janet Westhead and her daughter as a nuisance for whom they felt contempt, and they had agreed that Janet Westhead should be sedated, not for her own benefit, but, as I am sure, out of a general sense of contempt and to make their lives easier. As will become clear, it is relevant to know that Janet Westhead and her daughter are Scottish. On Saturday the 18th of February, Charlotte Wilmot was working on the unit on the day shift. She and Catherine Hudson engaged in text conversation, in which Charlotte Wilmot was complaining about the patients. Catherine Hudson expressed satisfaction that she was working nights and commented, as she put it, no dickheads had better be in there, or they are being sedated. Charlotte Wilmot responded by saying, piss myself laughing. In her evidence that going nights in this context meant being sedated. Catherine Hudson then asked Charlotte Wilmot to identify this patient as she thought it may be another patient. Charlotte Wilmot named two patients, including Janet Westhead, and stated that it was Janet Westhead who was to be sedated. Catherine Hudson replied, either way, in other words, whichever of the two it is, she's a stupid bitch by the sounds of it, to which Charlotte Wilmot At this point, Charlotte Wilmot pushed back a little, pointing out that if Janet Westhead died, or as she put it, pops it, Catherine Hudson would be answerable to the ward manager. It's clear from later exchanges that they came to share a contempt not only for Janet Westhead but also for her daughter, who was complaining vociferously about her mother's treatment. In an exchange on the 29th of February, Charlotte Wilmot was complaining to Catherine Hudson about Janet Westhead's daughter. She wrote, I had to walk away from Bed 30's daughter, rude woman, just like her mother. Catherine Hudson went on to ask Charlotte Wilmot whether the whole of Bed 30 are, as she put it, jock too. Charlotte Wilmot responded that Janet Westhead's daughter was indeed Scottish, and that she, Charlotte Wilmot, cannot stand Janet Westhead. She said, I have to stay away from her because, as she put it, I want to hurt her. She bemoaned the fact that because the ward manager had dealt with Janet Westhead's daughter, she, Janet Westhead, Wilmot came to regard Janet Westhead and her daughter with contempt. Janet Westhead's illness was to be mocked. Her vulnerability was to be exploited. A daughter complaining of poor treatment for her mother was insulted in the strongest terms. I'm perfectly satisfied on the criminal standard that when they had agreed, albeit on that earlier occasion, that Janet Westhead was to be sedated, it was of course to keep her quiet, to give them an easy life, but also out of contempt for a vulnerable patient. Thereafter they developed a deeper contempt and indeed ultimately a desire for some form of revenge. I've read the victim personal statement of Janet Westhead's daughter. Indeed, it has been read out. She speaks clearly of the difficulty in learning that her mother had been targeted in this way. This clearly affected her and indeed her own daughter. And again, I'm grateful for the statement which was read to me yesterday. I turn to deal with the final patient, Sheila Clark, who was ill-treated by Catherine Hudson on 2 occasions in early April 2017. Sheila Clark had been admitted to the unit on the 12th of February 2017. She was very poorly and accordingly very vulnerable. She was prescribed sedative medication, but as is clear from the evidence and the jury's verdict, Catherine Hudson sedated her for her own purposes, which had nothing to do with the patient's needs. On the 3rd of April 2017, Catherine Hudson was engaging in a text conversation with another member of staff. Catherine Hudson complained about the patients. For a week. It's clear from a subsequent conversation with Charlotte Wilmot that this patient was Sheila Clark. That subsequent conversation took place when Charlotte Wilmot was working and Catherine Hudson was not. Catherine Hudson was checking up on how effective her sedation of Sheila Clark had been. She asked what Sheila Clark had been doing, commenting whether this was an additional prescribed medication or an additional already prescribed dose is not, in my judgment, material to any sentence. Any unauthorised administration of sedative for a bad purpose is equally serious, whatever the drug. The victim personal statement of Sheila Clark's sister has been read to the court. She reports her sister's sense of betrayal at having been mistreated by those whom she trusted to care for her. I thank her also for her statement. There was other evidence before the jury that, particularly in the case of Catherine Hudson, she had inappropriately sedated other patients or been present when it had been done. That was before the jury as bad character evidence only, and she will only be sentenced for that for which she's been convicted. Those were not specimen but specific counts, and she'll only be sentenced for those offences. However, it is relevant to inform me as to why she committed these offences against the 3 patients whom she ill-treated or conspired to ill-treat. In this evidence that was put before the jury, Catherine Hudson talks of having, as she put it, sedated all the troublemakers and sedating the one who can be a nightmare. She said out loud. And also, if I'm in there tomorrow, the whole lot of them will be going night-nights. On an audio recording after her arrest, she can be heard telling her partner and her son about an incident when she was present, and another healthcare worker sedated a patient who they believe was causing problems for them with a cocktail of drugs. She told her partner that the patient was The only such exchange which involves Charlotte Wilmot is where Catherine Hudson sent a message to her saying, "Sedate him," and Charlotte Wilmot responds, "Ha ha, yay, sedation." In summary, these offences of ill treatment were committed by these defendants whose duty was to protect and care for them. The patients were as vulnerable as anyone could be. They couldn't leave the stroke unit. Some of them found it difficult to make themselves understood. These defendants exploited them for an easy shift, for amusement, to exercise a contemptuous power over them. Finally, I turn to the perverting the course of justice. From messages between them on the 10th and the 11th of August 2018, it's clear that Catherine Hudson and Marek Grabanowski disposed of drugs they had stolen in an attempt to frustrate the investigation. Marek Grabanowski told Catherine Hudson that he'd been throwing away medications and eating the batch numbers. Catherine Hudson advised him as to how the drugs could be safely disposed of, again stressing that the batch numbers should be cut off so that the drugs could not be traced. On audio recordings, the sound of blister packs of tablets being popped and then the toilet being flushed could be heard, which I am sure was them disposing of medication. They also discussed the lies they would tell and how they would need to brief Mr. Grabanowski's father to ensure that his false story, if ever asked, tallied with theirs. This was after the initial interviews and after their house had been searched. It's clear that the police had not found all of the medication which had been stolen, and they had set about disposing of the residue. They both knew at this stage that this was not merely an investigation into thefts, and of course the presence of Zopiclone and other sedatives in their house could have been important evidence in the ill-treatment investigation. In the event, it seems it had little impact on the police inquiries. I remind myself that all defendants are of good character. I bear in mind the character evidence before me in respect of each of them. In relation to Ms. Wilmot and Mr. Grabanowski, I have read the pre-sentence reports. I have read the apologies from Catherine Hudson and Marek Grabanowski. I note that Catherine Hudson does not apologise for the ill-treatment offences. There are, of course, elements of good character for all of them, which I have heard about in detail. I have read all of the references. I've heard about good things they did in the course of their professions as well as the bad. I note that all defendants have lost their good name. They've lost their profession. I note they've not offended since these matters, and it's now, of course, a long time since the offences of themselves. I take account of all of the personal mitigation. I take account, in the cases of Catherine Hudson and Charlotte Wilmot, that the work on the stroke unit could be extremely stressful and very challenging. I guard against double counting, noting that the vulnerability of patients and the breach of trust are implicit in the offence of ill treatment. However, even then, there are degrees of both vulnerability and breach of trust. But I bear in mind all that's been said on behalf of these defendants. I turn then to the guidelines. There is no guideline for the ill treatment offences. I refer to the overarching guideline. The closest analogous guideline is that concerned with cruelty to children, but the statutory maximum for that offence is far higher, and it is of limited, if any, assistance. I have in mind, of course, the purposes of sentence. I have in mind the maximum sentence for each offence of ill treatment being 5 years imprisonment. I then assess the culpability of each defendant and then the harm caused, followed by aggravating and mitigating features, and then the important question of totality. As for the thefts are at culpability A, category 4, based on value. However, there are additional harm factors in this case, which increase that to category 3. There is additional harm in that there was clearly a risk of injury to persons by the taking of prescription drugs without proper medical supervision. That gives a starting point of 1 year's custody and a range of up to 2 years in custody. In relation to the perverting the course of justice, this falls within B3 of the guidelines, giving a starting point of 9 months imprisonment and a range of between 6 months and 1 year. Stand up, please, Catherine Hudson. I first consider your culpability for the ill-treatment offences. You were in a position of trust and responsibility. You offended against vulnerable people in your care for the motives I've set out above. The offending was over a significant period. You were the leading offender in relation to the matters you faced with Charlotte Wilmot. In relation to Aileen Scott, you sought to engage the assistant of a student whom you were supervising and for whom you ought to have been setting an example, and you persisted even though she challenged you. It follows that your culpability is very high. It is difficult to identify particular physical harm to the patients directly affected. There was in relation to each a risk of harm, and we've heard evidence of the risk of administering sedatives to stroke patients. Furthermore, Aileen Scott is aware of what had happened to her. The relatives of all those patients affected will forever be distressed by the knowledge that their loved ones were treated with such contempt and that those responsible for caring them at their most vulnerable point acted to their detriment. There will be a loss of public confidence in healthcare workers. Other diligent and caring professionals will be demoralised and perhaps even feel that they are under unfair suspicion. In relation to the offences of ill treatment, the sentence is 24 months imprisonment on both counts 1 and count 4, consecutive to each other. On counts 5 and 6, there will also be sentences of 24 months on each, which are concurrent with one another, but consecutive to the sentences already imposed. Before adjustment for totality, that gives an overall sentence of 6 years imprisonment so far. For perverting the course of justice, the sentence after trial would have been 10 months in custody. With 15% credit, that gives a sentence of 8.5 months imprisonment. I turn to the thefts. I reflect the overall conduct in concurrent sentences. There are 9 theft allegations, including the particularly mean offence of stealing mebeverin from a terminal patient, that count being contested by you at trial. The number of thefts mean that there must be a more significant penalty than for the other defendants. The conduct is distinct from ill-treatment allegations, and there must be a consecutive sentence. To reflect the overall conduct, the sentence after trial on all the thefts would have been 2 years imprisonment. For credit, I reduced that sentence on counts 9, 11, 15, 16, 18, 19 and 20 by 15%, giving a sentence of 20 months. I reduced the sentence on count 12 by 10% to give a sentence of 21 months. The sentence on count 23, of course, remains for the time being at 24 months. All of these sentences are to be concurrent with each other, though consecutive to the sentences for ill treatment and perverting the course of justice. I then consider totality. For totality, I reduce the sentences on counts 1, 2, 5 and 6 to 20 months. All remain consecutive with each other, save for count 6, which remains concurrent. I reduce the sentence on the perverting the course of justice to 8 months. This will be consecutive to the sentences already imposed. I reduce the sentence on all the theft matters to 18 months, concurrent with each other, but consecutive to the sentences already imposed. And that gives an overall sentence of 7 years and 2 months. Sit down, please. Stand up, please, Charlotte Wilmot. In your case, the culpability for the ill treatment is not so great because you were only involved with 2 patients and you were not the leading offender. Your involvement was over a much more limited period of time. Catherine Hudson was your superior on the ward. However, many of the other indicators of high culpability apply to you also. I make the same observation in relation to the harm caused. I note, however, that on the jury's verdict, no sedative can have been wrongly administered to patient B. In relation to the offences of ill treatment, the least sentence I can pass is 16 months imprisonment on each count consecutive to each other. They were separate offences against separate patients. That gives so far an overall sentence of 32 months imprisonment. In relation to the thefts, there are far fewer than for Catherine Hudson. There is not the serious aggravating feature of stealing from a terminally ill patient. There is, however, still a very significant breach of trust, but you are not someone who is qualified to handle medicines at work. There is no theft of Zopiclone. The sentence after trial would have been 14 months on all concurrent with each other, but consecutive to the sentences already imposed. With 25% credit, that gives a sentence of 10 months on each, concurrent with each other. Subject to totality, that gives a total sentence of 3.5 years imprisonment. I further reduce the sentence on the ill treatment counts for totality to 14 months on each, consecutive to each other. I reduce the theft sentences to 8 months on each, to give an overall sentence of 3 years imprisonment. This sentence is too long to be suspended. Even if it were under 2 years, I would not suspend it. The ill treatment offences are so serious that they can only be marked by a sentence of immediate custody. Sit down, please. Stand up, please, Marek Grabanowski. The sentence after trial for perverting the course of justice is 10 months imprisonment. With credit of 20%, that gives a sentence of 8 months imprisonment. You are to be sentenced for 2 thefts, one of which was for Zopiclone and the other of a different medicine. The sentence for the thefts after trial would have been 40 weeks on each, concurrent to each other. With credit of 20%, that gives a sentence of 32 weeks. I reduce that to 6 months imprisonment for totality, but order that these sentences, whilst concurrent with each other, run consecutively to the sentence for perverting the course of justice. And that gives a total sentence of 14 months imprisonment. I've considered with care the imposition guidelines. In my judgment, the perverting the course of justice is so serious that it can only be marked by a sentence of immediate custody. Your plain duty as a citizen and a professional was to cooperate with the inquiry, not to seek to frustrate it. I note that you do not have caring responsibilities, nor is there any particularly strong personal mitigation. This is a sentence which must take immediate effect. Sit down, please. You will each serve half of the total sentence in custody, whereupon you'll be released on licence. In the case of Catherine Hudson, time spent in custody will count towards that sentence. If any of you breach a condition of the licence, you're liable to be recalled to serve the remainder of the sentence. I order that count 10 in relation to Marek Grabanowski shall lie on the file, and if the victim's surcharge applies, the order can be drawn up in the appropriate amount, and the defendants may go down.